they want things done in a hurry. They want to inherit their house, or they want to get the money that's in the bank accounts, and those things are frozen during the probate. So there's a time period that elapses. And so the normal period is anywhere from 6 months to 9 months to a year. Just depends upon what's involved. So it's a time, more time involved in probate. And also, as I mentioned, there's not that much flexibility. Assets get tied up. Bank accounts get frozen, and people don't like that. Whereas with a living trust, then it doesn't have to go to probate. A living trust does not have to go to probate. So that's a good thing. There is a process that you go through, but with a living trust, you have that person I call the successor trustee, and that person is now in control of all of the assets in the trust. And so they can administer the trust and take care of all those things, take care of the bills, and all of those things. And then when everything is said and done, they have the authority, if the house is going to be sold, they can list the house and sell the house, and they can distribute the assets. And so there's no, with a living trust, there's no court involvement. Also with a living trust, there's usually less time if there's no problems with the trust, and the trustee can usually take care of the business in a few months, and so there's less time, and it doesn't cost as much. The living trust doesn't cost as much as in probate. The other thing about a living trust is that the living trust is private. Okay, except for the beneficiaries who are part of the trust, then the rest of the public, they don't find out, what assets that you have and what's going on with your trust. Only the beneficiaries get that information. So the living trust is a private document. So that's the main reason that most people will choose a living trust, is because it involves probate. But since this is a senior resource fair, and I practice a lot of elder law and work with a lot of seniors, there's a really big reason why a living trust is better than a will. And that is because with a will, the will only takes effect when a person dies. But if a person is incapacitated, by that I mean if they're in a car accident, or if they have a stroke or a heart attack, or they have dementia or Alzheimer's or some disease where they can't handle their finances, they can't handle their business, then the will doesn't help you, okay, because you're not deceased. But a living trust, with a living trust, that can help you. It can be very helpful if you lose capacity, or if one of your loved ones loses capacity. Because with a living trust, that successor trustee now steps in and can manage your assets, and they can spend your assets on you and take care of you without, it's very easy to do that. If you don't have that, if you don't have a living trust, and you don't have, and your name is on the accounts, or your name's the only one on the home, and you don't have anyone, you don't have a living trust, then you end up with what's called a conservatorship. Okay, has anyone heard of a conservatorship? Okay. A conservatorship is another court proceeding, and I call it a living probate. And what happens is when somebody doesn't have capacity, and their name, it happens all the time. People have a heart attack, they have a stroke. Their name is the only name on the house. Their name is the only name on the bank accounts, the stock accounts. Bills aren't getting paid. No one can take care of their business. Okay? They can't do it themselves. And so someone has to go to court and file a petition to become what's called a conservator, to get the legal authority to handle those transactions. And that can be a nightmare. It really is. I mean, I talk to attorneys all the time who like to make money, and they don't take conservatorships. They don't like to do conservatorships because they're so complex and they take so much time and so involved that they just don't do it. And so for a person, for your family to try to handle conservatorship on their own is insanity. It's almost impossible to do that. But what happens with a conservatorship is that someone has to file a petition, first of all, to get a finding that you or your loved one doesn't have capacity, that they can't handle their personal affairs or they can't handle their finances. So that's a public hearing that you lack capacity. And there's court investigators involved, there's other attorneys involved, and after that process, someone's appointed a conservator. Then the conservator has the authority to handle your finances for you. That conservator also is required to come back and forth into court to do what's called accountings, and for major transactions like moving you or selling your home, that sort of thing, or making major improvements to your home, they have to get court approval for that. So then they're back in court. So they're in and out of court, and you're going to need a lawyer for that. So you really want to try to avoid a conservatorship. And the living trust does that, whereas the will does not. As I mentioned with the living trust, if you lose capacity, if your loved one loses capacity and can't handle their finances, then there's a successor trustee. And so the successor trustee, if you have a bank account and you have your bank account in the name of your trust, then the successor trustee can go to that bank and provide them with the proof that you don't have the capacity, show them the trust document, show them that they are the successor trustee that's named in that trust, and then the bank is going to put them on the signature cards, and then they're going to be able to handle all your business for you. Or if they need to, they'll be able to refinance or sell your home in order to help, take care of you. It's just easier to handle situations when someone is incapacitated with a living trust than a will. As a will, you can't do it. The other thing, again, is private. Okay, no one has to find out that you have dementia, you have Alzheimer's, or you're having some incapacity issues, except you and your family. And it's cheaper. You've already paid for your living trust, and so what happens is you've got a successor trustee, so the successor trustee just takes over. There's no need for any kind of court involvement